On Wednesday, the Supreme Court will hear arguments on a case that could affect the independent authority of every federal agency in the country. But to understand why, we have to go back 10 years. That's when a Securities and Exchange Commission found hedge fund manager George Jarkissi committed fraud and fined him hundreds of thousands of dollars. It's not unusual for the SEC to do this, but Jarkissi argued it was unconstitutional, and an appeals court agreed. The case in front of the justices asks three questions. First, does a federal agency have the authority to impose financial penalties without a jury trial? Second, can these agencies decide on their own which cases go to federal court? And third, who has authority over the judges who oversee these types of cases? We are grateful to be joined by CBS News legal contributor and Loyola Law School professor Jessica Levinson. Jessica, first, before we get into the details, let's start with the stakes. This is a case about the Securities and Exchange Commission, but there's a broader issue at play. So help us understand that broader issue.
Absolutely. I think the graphic explained those three issues. I want to use that graphic in my class when I teach this case. And so broadly speaking, this is about the power of federal agencies. As we know, federal agencies do things like set workplace safety standards. They set regulations for financial markets. They set safety standards when it comes to environmental protection. And so we're talking, as you said, about much more than just the SEC. Now, more specifically, we're talking about the adjudicatory power of these federal agencies, whether or not essentially these administrative law judges can make decisions over disputes, or if many, if not all of these cases instead need to be heard by a federal district court and potentially before a jury.
And is a key issue, or the key issue at stake, that trial by jury is a part of, it's in the realm of the Constitution. Constitutional protections are at issue here. When you have judges inside of a federal agency, that potentially tramples on an American's right to be tried in front of a jury.
So it's one of the three big issues here. It's one of the three constitutional flaws that the Fifth Circuit found with the way the SEC, and more generally, I think the way other federal agencies do business. As you said, it's in the Seventh Amendment. There's a right to a jury trial for all criminal cases, but also for civil suits in which you seek monetary damages, and it's a suit, quote, at common law. Now, there's a dispute about whether or not these types of suits, these types of enforcement actions, are the type that fall within an exception to the Seventh Amendment, meaning they're not a suit, quote, at common law. They instead involve statutorily created public rights, or if instead the Seventh Amendment says, no, you need a jury trial. Now, I know the case is complicated. Important for people to know, administrative law judges do not generally, almost exclusively, do not oversee trials that involve juries. Instead, that is in a district court where you would have a judge who oversees a trial by jury. And that's why it really matters here.
And so the second issue is whether a federal agency can decide if a case goes to court at all. Is that in this same question? That basically, if it's a constitutional issue, why is a federal agency making a call here?
So it's the next constitutional question here, and it deals with something called the non-delegation doctrine. And what the plaintiffs are arguing is that Congress doesn't have the power. They're giving up too much of their legislative power when they say to federal agencies, you choose if you want to adjudicate this dispute, if you want to have it basically in-house in front of an administrative law judge, or if you want to file this suit in federal court. Again, the argument is that that's taking away a legislative power from Congress. And the government saying, no, that's well within executive authority to be able to decide, does this go to an agency or does this go to federal court? Obviously, the implication, again, is that if plaintiffs win, then we have much fewer cases in front of administrative law judges. And for the time being, it would essentially grind these types of hearings to a halt because Congress doesn't at this point have the type of guidance. They haven't created the type of laws that would be needed if the court finds there's a non-delegation doctrine issue.
And they're having difficulty creating laws just in general. Finally, the administrative law judges who work at these federal agencies, they have job protections. So how does that all get changed in this case?
So the case is arguing the third constitutional issue here is about the unitary executive theory. And the idea behind that is that the president is head of the executive branch. The president gets to fire employees, or at least higher level employees. Administrative law judges have not the same protection as district court judges, but they have a lot of protection. The argument here is maybe they should be removable at will. The implications are huge because it could give presidents much more power over federal employees, period. A president who wants to come in and essentially erase the civil service that we are used to seeing, erase those job protections and put in political party loyalists would have much more free reign to do that, again, depending on what happens in the court.
Keeping the lines clear on the separation of powers. Jessica Levinson, thanks so much, as always, for being with us.
Thank you.